Okay, last time we left off with the American with Disabilities Act. By the way, you don't have to be an American to use it if you're here working on a work visa or otherwise here legally. The Americans with Disability Act will protect you. Anyway, the Act protects otherwise qualified individuals from discrimination solely because of their disability. And disability is defined really broadly. Okay, and so it's defined, it's described, and it's not like a list of things that are disabled. So there was a Handicap Act that preceded this that applied only to the federal government, and it listed certain things as being handicaps. That's the problem, because there's something you may forget and leave out, and so they didn't want to make that mistake, so they just defined it. Anyway, and we'll see the definition in a minute. The employer may be expected to make reasonable accommodations under this act. So actually, it was a big act, and there was a lot of things that were required. It also, the same act also applied to places where consumers were maybe buying. If you were a store or a restaurant and you had customers coming in, you had to make your restaurant, you had to make your store accessible to people in wheelchairs. And you had to make provision for people who might have disabilities, predictable disabilities that all the time are people who are just everyday people who are coming into a restaurant, so that people don't have to pick them up and carry them in. They can roll up the ramp on their wheelchair. And you've seen that in modern America, whereas when I was growing up in the 50s and 60s and 70s and 80s, generally speaking, there was very little accommodation for people. And if people were in a wheelchair, it was usually maybe sometimes embarrassing and a little bit difficult for them to have a normal life. But they certainly have taken care of that now. So the employer may be expected to make reasonable accommodations, and stores that had been making reasonable accommodations in terms of wheelchairs. And of course, it was actually a boon for people who were doing that kind of construction. Small construction firms could, then get work building ramps for restaurants and other stores. Okay, small stores maybe needed ramps, and other businesses maybe needed to broaden their offices so that people in wheelchairs could get between the desk and through the aisles. Anyway, so like I said, it was a much broader act than that. So what is a disability under the Act? Well, disability is defined as a condition or impairment that, one, substantially limits a major life activity. Well, what are we talking about there? Well, walking around is a major life activity, right? Seeing is a major life activity. Hearing is a major life activity. Being able to be part of society. So, if you're an alcoholic, you're not protected by the Act if you're an alcoholic, because it's presumed that you can actually control that. But if you're a reformed alcoholic, there's a danger you may slip into being that. But if you're reformed, you could be a very valuable employee. So you see this a lot in terms of certain professions. With accountants, oftentimes there have been very good accountants who had an alcohol problem, and they basically would be maybe entertaining clients, and they would wind up becoming alcoholics. Well, they might then realize that they had a problem and become reformed alcoholics. Well, as long as they're on the wagon, as long as they stay away from drinking, which could be hard in a situation where drinking is part of the culture. In some of these corporate settings, the corporate bosses expected people to drink with them. If you didn't drink with them, it was a problem. So I know my father, he was an accountant, he was the chief accountant at a steel plant, so he had to go out with the people from Chicago when they came down and saw our little steel plant in Newport, Kentucky. He would go out with them, and he'd take them out. He was responsible for making sure that they had a good time. So he didn't want them to know that he wasn't drinking as much as they were. So he had arranged with the various hostesses in, say, the country club where he would take them, Fort Mitchell Country Club. He'd have them, the hostess would know to tell the waitress to every other shot give him a blank, and he would buy something that would not necessarily show anything, like bourbon and alcohol. You can't see it, or a screwdriver. It just looked like orange juice, just maybe just an orange juice drink. He would have those kind of drinks. And even so, he would maybe still feel sometimes that he had too much to drink, and he would call me or my mother up to come pick him up. Anyway, so it's a problem in some professions. Anyway, disability, defined as a condition or impairment that one substantially limits a major life activity. Going out to eat with people is a major life activity. So you can see it's very broad indeed. Lots of things that you may have never thought of before are major life activities. If you can't do it, you're going to be left out. You're not going to have opportunities to advance. 2, a record of such impairment. Okay, so an alcoholic has a record of an impairment, and but it disables him, and he can't do the job, and he can't be trusted to do the job. And so any firm would be justified if they had an alcoholic who might embarrass the firm in any number of ways. So I knew an accountant who was a major partner in a firm. He was a rainmaker in some ways, and he was a guy they'd send out to entertain the clients because he was so likable. However, he one day was returning from a dinner, and he had this terrible wreck because he was drunk, and he killed a lady and her unborn child, and it was in all the newspapers, and the name of the firm was that, and that was the end of his career with that firm. He then went into private practice. He did manage to get by. There were some clients of the firm that he had handled and dealt with that went to him and said, we're going to keep you as our accountant, even though you're not with that firm anymore, because we know you're a good accountant. And we ourselves have had that problem. So they themselves had alcoholic problems, and they were reformed alcoholics, and they were trying to support another fellow who had the same problem, because it's really not a matter of morality. It's not a matter that there's moral failings in these individuals. It's really a sickness in some ways. There are genetic dispositions for these kinds of things. So, yes, and I know that's to be the case. I mean, it oftentimes skips generations. Anyway, being perceived as having such an impairment. You could take like the people who had AIDS. When the AIDS epidemic broke out, and people were worried about getting AIDS, and of course there was this restaurant downtown Cincinnati that was rumored to be, and I believe it was, run by gays, and all the waiters and the cooks and everybody in there was supposedly gay. They hired their friends, okay, and this was the rumor. But I used to go there with my friends because the food was so good. And the thing about it was that within a month of the national news that this AIDS was spreading and people panicking, people panicked and wouldn't go to the restaurant anymore. So me and my friends would go there, and we'd have these nice dinners, great service, very good food. None of us got AIDS. But people believed that these people shouldn't be serving them. They were such a scare. But I believe the science at that time that said you cannot get it from being served by a waiter. You can't get it even necessarily by him spitting in the food. if they would do that, we didn't think they would do that anyway. But anyway, it was great. And unfortunately, the restaurant lasted only about 2 months after that. And so for a while there, we were going and having great dinners and speedy services because the place was deserted largely. And I felt so sorry for those people, but this is life. When people have some idea and are not willing to pay attention to the science, they can make mistakes, and so it can be very hurtful to some individuals. If the impairment is correctable, then it isn't a disability. So for instance, I've been nearsighted probably all my life. I remember in the first grade I couldn't see the board. That continued until the 5th grade when they gave me glasses. And then suddenly I went from being one of the dummies in the class with a 3rd grade reading level to a kid, and 6 weeks later I had an 8th grade reading level. And ever since then, I was always considered to be one of the smart kids. Well, that brought a perspective to me. I really didn't think it was critical for me to be a smart kid. I wasn't really striving to. And I wasn't worried about my grades. I wasn't anxious. I knew I was going to get good grades. But if I got a C, it didn't bother me. But I had friends who were very good students, A students, and if they got a B, they were upset. And I always thought, well, what's wrong? It's okay. Anyway, but if the impairment is correctable, then it isn't a disability. Diabetes, nearsightedness are the two examples that I cite. Diabetes is correctable. Now, some diabetes is not correctable. So if you have uncorrectable diabetes, it's you know, it's a disease, and you're probably going to maybe be very handicapped. However, in some cases, I've known employers. I actually was, one of my first jobs when I graduated with my bachelor's degree was working in a department store, and we had a sales lady who was very good. You know, she was one of these, and I worked in the boys department, and she was one of these ladies that you could tell her that you wanted to buy a, you know, some pants, some jeans, and a shirt for the boy, and she didn't know the sizes, and you could tell, and they could tell this lady, her name was Mrs. Winkleman, I think. You could tell Mrs. Winkleman, she would ask some serious questions. How big was the boy? Was he chubby? Was he thin? And then she would pick out jeans, and nobody ever returned any of those jeans. She was always right. You know, just from the way they would describe him. She, you know, how tall is he? And she would pick this out. And she was a very good salesman, and the store managers appreciated her, and we were instructed that to let her take her break at any time, because it was correctable, but she had to take her medicine at specific times. So unlike the other sales ladies on the floor, she took her breaks when she needed to, and we never messed with her. The others, we would tell them, well, take your break when it gets slow, but she had to take it on a regular basis. We were making that reasonable accommodation. This was way before the Americans with Disability Act. This was in the early 80s. Anyway, shows you how old I am, right? I was a young man, a manager on a floor in the early 80s. If the impairment is correctable, and it is a thing, I just said that, includes reformed, disabilities include reformed alcoholics. So like we mentioned that before. Morbid obesity. What's morbid obesity? Some people are fat. Okay, that's not necessarily a disability. It's not a good condition to be in, but you know, people should try to lose weight. But morbid obesity is extreme obesity. This is a person maybe weighs 600, 700, 800, 900 pounds, 1,000 pounds. These people, and I've known a fellow like that, and unfortunately he died in his 50s when he fell over coming out of his bathroom and was wedged in the doorway, and the life squad couldn't get him loose to, you know, to keep him from dying, and he turned blue and died with his wife there all watching. It's a terrible kind of thing. He was a very talented accountant and very much loved by his students who he used to teach. But he had this problem, and he would tell me about it. He says he just can't help himself. He always eats. And you know, I think it's the same thing with alcoholics, right? I think there's some group of people who just simply have some sort of problem. Maybe it's some sort of chemical problem. I don't know what exactly it is, but I think it's similar to alcoholics, that they just can't help themselves but eat, or whenever they try to diet and exercise, they can't lose weight. It doesn't work for them, and so that happens. Anyway, those are things that are there. So there are lots of things that you might be surprised are actually disabilities. If it's going to prevent you from doing the job, if you can't do the job, then it doesn't matter. But if you can do the job with a reasonable accommodation, and so like I said with Mrs. Winkleman, we made a reasonable accommodation. We allowed her to take her breaks whenever she needed to, and there was always enough people to handle the floor. Anyway, defenses. You know, with this, and these are defenses that apply to other discrimination acts too. The first one is business necessity. You know, so as a business necessity, something may be necessary. And so very similar to this is actually bona fide occupational qualifications. So a business necessity might be a case where it used to be thought, and I don't know whether they're still doing this, that pilots couldn't be over a certain age because their reflexes would be slow, and you know, in some situations there might be a need to act quickly, and so these airlines would always let go of the people when they reached a certain age and wouldn't hire people who were that age. So business necessity. Or another one might be, say, if you were hiring people to teach in a Catholic seminary, and you're hiring this person to teach Catholic theology. You could require him to be, and this is an actual case, a Catholic priest. Even though he might have previously been a Catholic priest, but he's now become a Buddhist, which was the case, you don't have to hire him, and if he's working for you, you can fire him at that point, because it's a business necessity. Another way of saying it is a bona fide occupational qualifications. So there are very few of these kinds of bona fide occupational qualifications, but for instance, a priest, or in religious context, oftentimes the person teaching theology or performing the ceremony must be a member of the religion. And you know, and this can go quite far actually. And I know of a case involving a teacher who was teaching 4th grade students. She had been divorced by her husband, and she was dating young men. She was still a young person herself. Wanted to have children sometime, was probably planning on marriage. No indication that she was doing anything wrong, but according to Catholic Church, a divorced person cannot get remarried. And so she was seen by her students, young students, and 4th graders, out in the mall with her boyfriend. And so they talked about it, and they told their parents, and it became widespread, and everybody knew about it. It got to the bishop of that community, and he directed the principal, who knew the situation, that he should fire the young woman, and that's what they did. The principal objected that she was a very good teacher, and he didn't think she was doing anything that would be embarrassing for them otherwise. But yes, she was divorced and she was dating, and so they fired her. And so, I mean, they can do that. It's a religious accommodation, you could say. Another one would be, everybody see Victor Victoria? In Victor Victoria, you see a young woman who pretends to be a female impersonator. She's not a female impersonator, she's a female. So if you go and apply for a job as a female impersonator, you have to be a male. You know, you wouldn't qualify. So that's it. Now, in sports, I remember about, back in the 80s, there was a time when women challenged the rule that only men could be hired to report on sports after the game. So after the game show, they had to have a male reporter go into the locker room. Well, women were not supposed to be going into the locker room. Sporting clubs wouldn't allow them. And so they complained, and the sporting clubs were made to actually make some sort of reasonable accommodation. So they had to set aside a room where men could come in and be, properly maybe attired after the game, shortly after the game, and be interviewed by whatever reporter was sent in there, so that female reporters could actually perform that job. That was an actual case. So BFOQ is a defense, and sometimes it means that you're maybe discriminating, and other times, so if a female showed up and wanted that female impersonator job, and they knew she was female, they could not hire her, or they could fire her once they found out. Anyway, seniority systems is another defense. Seniority systems result in people who've been there a long time being paid more than people who've been recently hired. So what you had in 1964 was an act, and you had under that act an interpretation that allowed for affirmative action. And courts would order firms to actually adopt an affirmative action program, and basically these firms were given a timetable, and they had a schedule, and they had to bring up their employment of blacks. So there was an estimate made as how quickly they could, equalize their workforce. It's what that. It's not actually equalizing. They don't actually have to equalize it, but they have to correct, and approximately they have to correct the imbalance in the workplace. And this is a matter of statistics. So in the South, you had firms, manufacturing firms, that maybe had 100 assembly line workers. Assembly line workers were not workers who had any skill. All they had to be able to do was to maybe screw a screw in, or put something on the thing. They could be most people could be easily instructed to do that. It was considered an unskilled job. So it's not like a craft. These assembly lines in the South in Birmingham, Alabama, which was I think at the time 60% black in terms of unskilled labor anyway, maybe 80% black. Anyway, so you know, they would have all white assembly lines, and you know, so the statistics very much was very obvious that they needed to balance those forces out. And so what would happen if a firm, say, began to hire blacks? Now, you know, the order of the court, the affirmative action order, wouldn't require them to fire anybody, but the persons who were working would be required to actually, you know, for new hires, they would have to maybe give a preference to, you know, although they usually didn't say it that way, but it was really a preference that they were giving to black workers to try to bring up that. So they were expected to reach their goal. Now, you know, theoretically they were still looking at people and making individual decisions on them, but let's face it, in order to reach the goals, they had to hire blacks pretty much as a rule, and occasionally maybe they might get by with somebody who, but they had to meet their schedule, so they had to meet their quota. Well, what happens if business has a downturn? What if their products is no longer in demand and they have to lay off people? Who are they going to lay off? They're going to lay off the most recently hired. That's just standard business practice. And they can go to court and they can explain to the judge what happens, and the judge is not going to hold that against them, because oftentimes they would be compelled by their labor contract, their collective bargaining agreement, they'd be compelled to let go of the more recently hired people, or it just might be a policy that they have adopted and that would be recognized. And so you'd have these seniority systems, and they weren't able to reach their goals, so the judge would rewrite their schedule and give them further time to do it. But so their seniority systems have that kind of things. So anyway, after acquired evidence of wrongdoing, if you're, let's say you are a minority, but you've gone to school, you got an education, you got really good grades, and you apply for a job working for Human Resources Department, your degree that you've been studying for is actually in psychology. You haven't gotten it yet, but you're certain you're going to get it. You have one more course to do, and you've been interviewing for this job, and you know you haven't gotten the degree, but you're indicating to the employer that you have gotten the degree, and he hires you. Later, 2 years later, he finds out that when he hired you, you didn't have the degree you said you have, and he fires you because you lied to him on your application. That's called after acquired evidence of wrongdoing. Okay? And can he do that, or is he discriminating against you? You think he's firing you because you're black, and or you're a woman, or whatever. You think you're being discriminated against. Is your case blown out of the water by the fact that you lied on your resume? Yes. So don't lie on your resume. Just tell the truth on your resume. It's just going to provide an easy way to get rid of you at some point if you're no longer wanted or inconvenient, or for some reason they just want to get rid of you. In some cases, there's terrible things happen in the workplace. I've heard of people being discriminated against because they won't go along with the culture. And it's the culture involves maybe they're required by their boss to lie to his wife about his goings on and going to you know, with some of the young women who he's working with to lunch, but you're to tell her not. He could just simply arrange for you to get hired because he has the resources, and he'll get people to maybe participate because they're all part of a culture that does that sometimes. So don't be lying on your resume. Tell the truth. Tell them they understand that you'll be getting your degree. They can see that you've got good grades, and you know, they can call up your teachers if they want, and the teachers can tell them maybe, oh yeah, we think she'll be doing fine. Anyway, so after acquired evidence of wrongdoing, other legitimate reasons for discriminating. Well, for instance, insubordination. It's not discriminating against a person if he's being insubordinate, if he's talking back to others, including other workers, if he's causing trouble. Tardiness. Now, I will put a caution in there. There have been any number of cases where somebody was fired for being late Well, if he's not very much late, just say a few minutes, do you fire people for being a few minutes late? No. I mean, in a lot of places, they'll tolerate you being late. You know, you come in, you explain whatever happens, and you know, and that's that. But you know, if you fire a guy for being 3 minutes late, I think you're going to open yourself up to the charge that it's a pretext. The pretext is not the real reason, and so he might claim you're doing it because he's black, or he's Arabic, or you know, he's Jewish, or whatever, and you know, that's insubordination. I'm not insubordination. That's tardiness. Okay, so you know, that might be tardiness. Might oftentimes is going to be maybe thought to be just simply a pretext, and so it'll go to a jury and they'll decide. But you can imagine the jury oftentimes think it's something that employers don't do. They probably know from experience, maybe. Theft. So if you've been caught with your hands in the till, if you've been caught stealing, that would do it. Some people maybe get fired when somebody says that they were the person stealing from the cash register. And if they can find out that that was the case, then they can sue for defamation of that individual who, you know, supposedly told this lie about them. And so that individual is going to have some sort of proof, maybe beyond just simply his say-so. So it becomes your word against his word. And why should they believe him as opposed to you? Or is it indeed some sort of discrimination that they're doing against you for whatever it is that you believe they're discriminating against you for? Anyway, another one is theft, or how about attempted theft of property? Okay, you're fired for, you and your buddies decided to steal a truckload of the product that your employer produces. So I worked at a plant where about 3 or 4 individuals I knew actually tried to steal a truck full of the lights that we were making in that manufacturing place, and they were caught and they were fired. There's no question about the justification for the firing. They can't claim any sort of discrimination, even if they could. It's not going to go anywhere because they could fire you for attempted theft of property. Didn't actually get that truck, by the way. They got caught in the middle. And incompetence, of course, if you're not able to do your job, you can be fired. You know, of course, they have to prove it. OSHA. Purpose of OSHA is to ensure safe and healthy working conditions for employees. So one of the reasons that some people say that unions are not maybe doing as well as they used to, that there are lots of places that maybe you might expect to be unionized that are not, is that we have so many other laws now that protect them. So it used to be, say in the 30s or 40s, 50s, 60s even, a lot of workplaces may have been unsafe because of conditions that employers allowed them to happen. Well, one way of correcting that at that time was to have your union bargain for and insist upon safer working conditions and very specifically lay out what must be done. And that was one thing. With the creation of OSHA, the Occupational Safety and Health Administration, you don't need to think about that now. So OSHA, you know, it's affected things maybe in many ways that you wouldn't necessarily think. Now OSHA has various kinds of things. So there's enforcement. OSHA establishes rules. As an administrative agent, it establishes rules that have the force of law and regulations that have the force of law and safety standards that have the force of law. So if you're violating these rules, you're subject to the penalties imposed by the agency or by a statute if there is such provision in the statute itself creating OSHA. So you have the enabling legislation that creates OSHA, and it's given the responsibility to make these rules and regulations and to enforce them. Then there is, part of OSHA is also something called NIOSH, which is the organization, part of OSHA, that recommends the standards for adoption after researching safety issues. So how much lead can you be exposed to if you're in a battery plant? So in a battery plant, you know, they have to test for how much lead people are exposed to, and they could have a different standard for different people. So if you're a pregnant woman, your standards, your exposure to lead needs to be a lot lower, and so you might not be allowed to work in a part of the plant where you would be exposed to a good deal of lead. Instead, they may have to try to find some other place for you to work. In other words, maybe they move you to the office. You know, of course, that's if you're qualified. And so, yeah, NIOSH sets the standards. You can still have your union setting standards that are even higher than OSHA's standards, higher than what NIOSH would recommend. You could do that. You could bargain for at even, you know, higher standard with a union. But like I said, unions have been on decline. I think the high point of unions was maybe, what, in the 1947, I think, in 1947. There were 3 million workers in 1933 when they adopted the National Labor Relations Act, but by 1947 there were 15 million union workers, and I think that was the high point. Since then it's been declining, and I think some of the reasons may have been that people didn't think it was necessary anymore. Nowadays I think they may be reevaluating that. I mean, workers might be reevaluating that. However, I think there's a lot of fear. Anyway, OSHRC handles appeals from actions taken by OSHA, so that's part of OSHA too. So they have like a lot of agencies do. Some agencies only can make rules and regulations, and you know, they can't do much more than that. So in the EEOC, you have an agency that actually can make regulations and guidelines, and so for instance they come out with guidelines saying what sexual harassment is and what you should do to avoid being held liable, and you need to follow and comply with those guidelines. And so these things have the force of law. And now EEOC cannot bring a case in a court of law. Oh, well, actually they can, but they don't have to bring a case in a court of law. And they cannot actually rule on cases. So they have hearing referees, I think, are not really administrative law judges to actually can decide cases. They can make recommendations, you know, but, you know, and they can try to negotiate a deal with the employer who might be seen as discriminating, if they believe it is discriminating. But generally they're going to issue a right to sue letter to people after a while. But you have to go through them in order to get that right to sue letter. The right to sue letter pretty much is issued any time they decide not to bring the case automatically. So they don't actually decide the case. That means that they're not going to decide that you're not entitled to it, but they will decide and make recommendations to you, and they will, and this will be known by the employer. So, you know, maybe you're going to have to build your own case. So that's not something they do. Pretty much they do have the power actually to bring cases, they just don't do it. But here with OSHA, you see they have these regulations. They have inspectors going out and making sure that they're complying with the regulations, so that's enforcing the law. And they can file suit. It's a civil suit. They cannot file a criminal suit. So if there's a criminal provision in the OSHA Act, that has to be enforced by the Department of Justice, because that's the one that enforces so that's true of all agencies. All administrative agencies created by the Congress or legislature, they never have criminal prosecutorial powers. They only have civil powers, so they can fine you. That's about it. They can fine you, they can issue a cease and desist order sometimes, but they cannot throw anybody in jail or find a company to be having committed a criminal act. If they believe you have committed a criminal act, they can refer it over to the DOJ, and they will do that. Okay, so that's OSHA. Okay, so the procedures in OSHA is pursuant to warrant or with permission, OSHA may inspect for violations. So basically, they can't come in at any time and just inspect. So the Act said that they had a right to come in at any time to inspect. But they were challenged on trying to go into a plant one day, and the challenge was that they needed a warrant to come in and inspect, or they had to be invited in. And the guard told him he'd been instructed not to allow them in if they came. And you know, the inspectors said, well, let us talk to your boss. So they talked to the boss and says, he's right. We've been told that we do not have to allow you to inspect it. I know it's in the statute, it says you can do it, but Congress cannot give you a power to do that you have to get a warrant from a court. And so this is our Fourth Amendment right. That's what our lawyer told us. And so this was appealed to the Supreme Court, and the Supreme Court upheld the guard and the supervisors and the lawyers' information that this was a Fourth Amendment violation. In order to come in, they had to show they had to have some sort of suspicion that there had been a violation of the statute. They just can't go around on a fishing expedition to find anything that might be out of place. But you know, it's sort of like a teacher who wants to do pop quizzes. It's one way of making sure that people are doing what they are supposed to do. And so I can understand why OSHA thought that would probably be a good idea. Anyway, they can come in if there's an accident without a warrant. Or they can come in and they can schedule. If they call you up, you have to schedule a time for them to come in and inspect. So they do have some right to inspect it, but they have to come in when you tell them it's okay. So they'll know ahead of time that they need to get up the posters that they need to have up, and they need to have everything in place at that time. So, you know, in some ways, one wonders what kind of enforcement can they do. Anyway, employers with 11 or more employees must keep occupational injury and illness records and report to OSHA deaths or hospitalization of 5 or more employees due to workplace accidents. So when there is a workplace accident, they have to call up OSHA and tell them, well, we had this guy, he had to rush him to the hospital. He was, you know, driving this forklift, and the molten lead that he had in a tub spilled over onto him, and he's got these severe burns, and he's been taken to the hospital, you know, and he dies. Okay, now they're going to be able to inspect that. So these kinds of serious accidents will give OSHA a right to just come in and inspect it. They no longer need your permission. There's been a serious accident, they can come in and inspect and investigate what happened. So following an accident, an inspection of the workplace is mandatory. That's what the statute says. So they don't need a warrant at that point. OSHA penalties of violations may be fined if the violation involves state criminal laws. So, you know, reckless endangerment of a life might be a criminal violation under your state's law, and therefore you can be prosecuted by the state, not by OSHA. Same is true of, say, situations with the labor unions. If the company is committing criminal violations, it could be prosecuted. So, for instance, there was a plant. This was an OSHA violation, actually. There was a plant, I think, in one of the Carolinas. I don't remember whether it was North Carolina or South Carolina. And this plant processed chickens. That is, they employed people to chop up chickens and pack them in boxes. Okay, so they were a processing plant for chickens and other kind of foodstuffs. Anyway, they were, you know, you know, this was in the South, and so at that time, the South was very hot, and you know, sometimes it would be very, very hot inside the building, and it wasn't air conditioned. Back then, very few plants would have had air conditioning. I don't know if they do today, but you know, I used to work in plants back then, and they didn't have air conditioning. None of the plants I knew, even the very best plants, didn't. I heard that there were plants somewhere that had it, but I just never knew of one. Anyway, so it was very hot and very, you know, stultifying. You got these chickens that have been boiled. You got all this heat in there, and people would sneak outside to get a breath of fresh air to cool down. And the company didn't like that. They wanted them to be working all the time. And you know, if they took a break, I think they were required, and this is actually considered to be a violation today, to go and clock out to take a bathroom break, you know, and so they could keep track of how much breaks that people were taking. Nowadays, I think this is considered a violation. You have to allow people to take these breaks. And I suppose if somebody is abusing it, you can maybe try to prosecute, but I imagine it would be very hard, because sometimes people are having difficulties and might need to go to the bathroom more than that, especially women sometimes with their period are maybe also very much under the weather in some ways. And so if the violation involves state criminal laws, and this chicken plant, they were actually locking the outside doors, which is a violation of the fire code, which was a criminal act. And so they could have been prosecuted by the state, but they weren't. And OSHA didn't do anything to them either, I think, because they had opted out of OSHA inspection. So they were, at that time, you could actually opt out of OSHA inspection by saying that your state is going to do the inspections. But the state never did inspections. And so that was certainly encouraging people maybe who wanted to keep their costs down to locate in North Carolina or South Carolina. One of those. It's either, I don't know which one it was at this point. Can't remember now. Workers' compensation. Either employers must purchase insurance from the state or from a private insurance firm. So they you know, most of these statutes nowadays allow an option for them to do that, and also the employer can maintain that he is self-insured. Now I don't know, each state I suppose has to approve this claim that they're self-insured, and I don't know what kind of things they require. I would imagine to be self-insured that you would set up a fund out of which you could pay a predictable number of possible injuries and deaths that might occur given your history and given the history of your industry. I think that would be, to me, a very reasonable kind of thing to have in the statutory scheme. Whether they have that or not, I don't know. But I know that the workers' compensation statutes vary from state to state, and quite frankly, it's like that Carolina state. Maybe there's a lack of enforcement. I mean, sometimes state officials don't do what they want. So I live not too far away from a certain nightclub, which was very popular in Cincinnati, and one day it actually burned down to the ground, and people were trapped inside and died. And there were lots of code violations that were meant to prevent fires, and that was in fact the case. So workers' comp, let's take a look now at workers' compensation. Claim requirements. The employer, there has to be an employment relation. So if you're a worker and you've been injured on the job, you have to show, and you have to have an employment relation. So you can't, if you're working for an independent contractor, you should be covered by him, and he should maybe have the workers' comp. If you're hiring somebody to, do your kitchen, so you want to fix your kitchen up and modernize it, and you hire somebody, he's a contractor, and he hires other people, he's got subcontractors, people who work under him. You need to check and make sure that he has workers' comp so that they don't wind up suing you if they get injured. If there are conditions in your place, which will actually happen oftentimes when they're doing construction, things will be askew, things will be torn up, and electricity may be exposed, and people might be exposed to wiring, and all kinds of things can go wrong. And so you want to make sure that he has workers' compensation so that you're not involved in a lawsuit with potential liability. But same goes for an employer. You need to do that. So for instance, we have a case in Indiana, I think I talked about, where there was a gas station and the truck driver was behaving badly, and the employer of the gas station attendant got sued when the truck driver poured gasoline on him, if you remember that case. And so this is the same kind of thing. Shouldn't happen, but it sometimes does. So there needs to be an employment relationship. Injury was accidental, not self-inflicted. Okay, and so occurred on the. I don't know. A lot of employers will claim that a lot of employees. I oftentimes am very skeptical about whether or not people inflict terrible wounds upon themselves to collect money. Injury was accidental. They'd have to be awful desperate, wouldn't they? So it's very easy to claim, oh yeah, he did it to himself. It's oftentimes maybe a pretext. Occurred on the job or in the course of employment, not while commuting or to or from the job. Notify the employer usually within 30 days and file. It could be different, depends on your state. And file with the state within the statutory period, or file with the private insurer, or file with the employer if he's self-insured. And he has to provide you with information on these kinds of things as to where to file. And he should do that when he hires you. Workers' compensation versus litigation. One of the reasons that we had workers' compensation was, one of the reasons it was created was that employers didn't like the fact that if they were found to be negligent, or their employees were found to be negligent, they could be sued. And so in order to avoid that litigation and the cost, they basically, the state would create this system where workers would get paid automatically, no questions asked. So defenses such as assumption of risk, contributory negligence would not be applied. You know, you lost your hand on the job, you got so much for a lost hand. So anyway, we'll take a look at Indiana's here in a second. Common law defenses don't apply to these claims. Contributory negligence or assumption of risk do not apply. If the injury was intentional, the employee may sue the employer. You know, so or intentional, or the employer should have known you were injured, you might be able to sue the employer. So sometimes supervisors get a little bit excited. In that case I talked about the molten lead falling on the guy, that was a case where the supervisor told the person, yes, go ahead, you know, I want you to take it and dump it over there. And he insisted the guy did. The guy didn't want to do it. He thought it was dangerous. But the supervisor said, you got to do it. And so he should have known better. And in fact, the driver, even though he was knew better, but he went and did it after the supervisor told him to. And they sued, and they actually won at the trial court. But I think on appeal they lost. But that's another story. If the injury was intentional, the employee, but this is the only way you can get out of this no litigation. So basically the workers' compensation statute says that you can't bring these lawsuits. But if you can show that it was intentional or it was done recklessly, with reckless disregard for safety, then you can get out and actually sue them. And so that's a fairly stiff standard to do. Otherwise you're just stuck with whatever is given to you by the statute. Medicare, okay, we're not going to talk about that. That's something that you get for being old, right? COBRA is another thing. The employer must allow a discharged worker to continue his health care coverage for 18 months. Benefits and coverage must be the same. If the worker knowingly and voluntarily discontinues, then the employer is released. So, you know, you got to tell your employer that you're going to leave to get this benefit. Ends if the worker obtains other coverage. So if he takes a job somewhere else and gets coverage there, the employer's off the hook. Electronic monitoring, to a limited extent the law allows employees to engage in electronic monitoring, but not to the extent that the employees' reasonable expectations of privacy are violated. So the employer typically needs to tell you if he's monitoring you. If you're able to use a phone and you're okay with that, he has to let you know that he's going to be monitoring it. Most employers will monitor phones because they don't want to get sued by somebody if you're doing something you ought not to be doing with the phone, like soliciting pornography or something, I don't know. Or may consent to monitoring, or you're harassing somebody or something, you know. So they want to know how you're using the phone. And so they'll monitor. They want to make sure you're not doing something you shouldn't be doing. Polygraph test. Employee or job applicants take lie detector tests. Sometimes it can require them to take lie detector tests. Let's say somebody's been stealing money from the cash register, so they want to find out who's doing it. They're going to ask people to take it. You could refuse to take it. If you are actually forced to take it, just insist that your lawyer be there. Using, accepting, referring, or asking about the results of such tests. Threatening to penalize employees who do poorly or refuse to take the test. They can't do that. Age testing, prohibited by some states. Use of these in employment decisions prohibited by Americans with Disabilities Act. I think that's it, and thank you very much. We'll pick up next time with labor laws and see how those work. And so thank you very much for being here, and I enjoyed tonight. I hope you did too.